Hey everyone, this is Stacy Lake. I am doing a surprise live today to cover the Supreme Court arguments live in this in with regarding the abortion question. But I think the Supreme Court's website, their live streaming website, is actually crashing right now. As you see, the uh, this is from my computer. The streaming is frozen here, and this is my phone that is on the actual web, like a cellular internet that's also not able to stream this argument. So I don't know what's going on. I mean, I'm kind of miffed right now because if they're unable to handle the volume of people looking at their live, they should have just have an audio link to listen to the oral arguments live. Or they should have had their streaming on YouTube, and then they wouldn't have this issue with, I believe this is a server issue. But if this if it's like this for the next 10 minutes, then I'm just going to end it. But this is wild. Like I know thousands of people are probably trying to watch this, if not tens of thousands. That's why I'm like, look, CaseNet, I know you try to do your own thing. You're like, hey, instead of using YouTube to stream these oral arguments or to stream the Supreme Court, we're going to have our own video sharing platform. But these are the reasons why sometimes that does not work. And right now I'm checking my phone to see if my phone is able to access this again. Which just is crazy, man. I wonder if I'm going to pull up KCUR to see if they actually have like some sort of other live feed.
KCUR streaming is supported by the MCC Foundation.
Hold on a second. Yeah, I'm still not getting it on my phone either. And this is cellular communication, so it's not an issue with my internet connection. Oh. Is it working now? Let's see. Yeah, my cell phone is still saying that it's not loading. I don't know why people don't want to use YouTube. It's free. It's crazy. Yeah, for those of you just joining me, the oral arguments, it's frozen right now. The live stream is not working on my computer, and then when I pull it up on my cell phone, which is using the cellular networks, it's also frozen. So uh, that's where we are right now. I think there's too many people logged on to the court servers, and therefore it's not being broadcast. Hey Sam, thank you. Thank you. It's not working for other people either. So thank you for confirming it's not my own issue. As I stated before, I'm going to stay on this live for 10 more minutes, because if it's like this, then what I'll do is I'll just have a live later on after they posted their oral arguments. But this is ridiculous. Because and this is ridiculous because, one, YouTube is free, but two, they should have an audio link that would be able, it would be easier to stream audio on the court website than video. And also, they should have a WebEx link too. They could have done this through WebEx. And for people who don't know, the courts usually use the WebEx system. And so I'm going to actually go to the case itself to see if there is a WebEx link. Let's see. Sorry if I'm looking serious right now. I'm going through a lot of text right now. Yeah. The only broadcast they're allowing is this stream. Hold on a second. And if it's working on anybody, like Sam, if you're still there, please let me know if you got it up and running. Because who's KY3? Oh, it's a news site. Let's see, KY3. Sam, if you can send me the link to that stream, that would be great. I'm going to try to find it on my own. I got it. I got it. Hold on a second.
Voters of the state of Missouri and signed an initiative petition.
Please let me know if you can
ask
hear
their
this
fellow
audio.
citizens to
Thank
vote on
you,
whether to
Sam,
amend
for letting me
Missouri
know about
Constitution
this stream. But
November.
please
The
confirm you can
issue
hear
on
this
which they asked for a
audio.
vote, reproductive rights, is no doubt a controversial one. The court may take judicial notice. But the fact that it's controversial does not mean that the courts and the state officials should cast aside the fundamental right to have that vote. Nor should we cast aside the rules and protections that this court has held sacred around the initiative petition for my entire life.
Can you guys hear
before,
this audio? Please let me know.
Those processes protect us all, whether we call ourselves pro-choice or pro-life, or whether we decline to accept either of those labels. And they protect folks who aren't part of this debate, but want to have other debates about things like whether to raise taxes or whether to have marijuana legalized. You may not like the initiative petition process. When I say you, one may not like the initiative petition process, and we're going to have that debate probably soon about whether initiative petition is the right way to run a government. But today, the Constitution guarantees the right. Throughout history, this court has been called upon to protect the initiative petition, from the Hancock Amendment to right to work to taxes on tobacco products to abortion. You've held fast and acknowledged that reservation of right to the people and their ability to amend the Constitution, importantly, independent of the General Assembly. That's the language. And the need for you to do that, the need for the judicial system to protect the people from interference in this process, is at its greatest when the subject matter is highly controversial. And this matter, now known as Amendment 3, might be the most controversial one yet when you look back. Of course, to other people, theirs was probably the most controversial. The courts, including this one, have already been called upon about this matter, about Amendment 3, to protect the process against interference by elected officials opposed to the goals of the measure. And it's okay to be opposed to the measure. That's the debate that makes democracy work. They can go out and have that debate and discussion, but the time and the place to talk about whether Amendment 3 is a good idea is in November and the campaign leading up to November. It's not here in this courtroom or in the courtroom down the street in the Circuit Court of Cole County. The courts have not and should not allow themselves to be used in attempts to take away the right to have the debate. In this case, a group of plaintiffs who oppose the goals of the measure bring their political complaints to the courts rather than to the voters. Their goals are obvious in the timing of their challenges. They have known about the defect of which they complained for over a year, but waited to bring them until 19 days ago. Their goal is also obvious in the arguments they have advanced below and before this court. The brief here is light on legal arguments, but weighty with political argument, including, as you may have noticed, a discussion of news articles, tweets, and Nigerian polling data, none of which is in the record below or relevant to the issues before this court. This is not a serious contest about legal issues, but about the meaning of the statutes or the Constitution when you put all of it into context. These are political arguments that are thinly veiled, covered in legal language, references to statutes with light touches on select language from case law that might be of help. But respondents point to no case that has ended the way they want this one to end, which is to deny the right of 254,000 plus signers of the initiative their right to ask citizens if they want to vote. In this particular attempt to derail democracy, plaintiffs raised a procedural requirement about the form. And when it was, as I said, when it was filed over a year ago, the measure advised that it would add one section of the Missouri Constitution, and that's exactly what it does. The precise dispute, as the circuit court below focused on, is the construction of 116.050. The plaintiffs say it requires the measure to disclose much more than the fact that there will be one amendment to the Constitution. They say that the proponents were required to predict which statutes might be invalidated or curtailed if the measure passed. Those statutes, if the measure passed, if those statutes are challenged after the measure passes, and if the court's inner orders interpreting the Constitution, they say the proponent should have anticipated how that would have gone down and included it in the disclosure. First, this is a statute passed by the General Assembly, and the people have reserved their right to the initiative independent of the General Assembly. That's an important overriding concern. Second, it is not required by the plain language of section 116.050 in several ways. And we've covered, I always, when I have these expedited ones, I think, what am I going to tell you that I didn't tell you at noon yesterday? So I'm trying to summarize a little bit what's in our brief. The plain language of the statute, which of course is where every statutory analysis begins, does not require the disclosures that the circuit court seems to think it does. It requires a disclosure of what is repealed. And it does not say that the proponents must disclose changes to statutes or repealed by implication. And that makes sense because constitutional amendments here first do not repeal statutes ever. You're being asked in this case by both sides, as the secretary pointed out, to declare a statute unconstitutional. The respondents believe you should declare the statute that purports to limit the court's authority to make changes after this Tuesday. They say you should declare that unconstitutional. We say that under certain circumstances, which I don't think you need to reach at all, 116.050 is unconstitutional. If you were to write an order agreeing with either of us, it would not end with, therefore we repeal the statute. You've never done that. The courts have never repealed a statute, and the courts have no authority to do so. What the statute is talking about is legislative repeal. Initiative petitions are legislative actions. What the statutes are doing is requiring initiatives to mirror what the General Assembly does when it puts a bill before its own body to be considered. And this court has seen many of those bills. It begins with a very long list of numbers of statutes that, by the way, would mean nothing to your average voter. A lot of times I have trouble figuring out what they are, and I spend a lot of time in the statutes. The General Assembly never, when it passes a bill, looks to see what statutes might be repealed by implication or what might be effective. That's never included in the language of the bills. They just list the ones that are expressly repealed. I believe that's the correct interpretation of 116.050. It's a plain reading.
But would you agree that our cases don't say that?
I would.
Our cases don't say, our cases talk about it, whether or not they directly conflicts or irreconcilable differences, or that's the language that our cases use. So try to explain how we can interpret the way you want to interpret the statute based off our prior cases.
But so interpret it in the context of those cases?
Yes.
I will. Let me start with this. Buchanan, Ritter, Knight, which is the main string of those cases, got to the right result with the wrong reasoning. All three of those cases found no repeal. So they reached the right result, but they did engage in this reasoning. And if I might have an indulgence, I feel a little bad because I was in Ritter and I feel like I might have contributed to it. Because in Ritter, it was pretty easy to see when you look through it that there was no repeal by implication. So that's fine. Let's talk about it and let's argue it and let's analyze the fact that there's no repeal by implication. Okay. That was the context in which that case was presented. That was the context in which that decision was made. I think the logic is wrong. Just to be clear.
What about add some discussion about the Marsh versus Bartlett case?
The older case?
Mm-hmm.
Yeah, which
Isn't it? Aren't those cases in line with it as it relates to what would be considered a repeal as it relates to initiative petition?
So, Your Honor, moving this fast, I don't have Marsh versus Bartlett on my list. I have Halliburton and Moore versus Brown, both on my list. Cases pre-1945 are a little bit of a different animal, under a different constitution, and frankly, under a different way of thinking about the initiative petition, in my view. And if I might be so bold, is that case one of those?
At 1938.
Yes, sir.
I was mainly focusing on the issue, though, that Judge Powell was talking about as to what would be included in a repeal, not necessarily the older provisions of the Constitution.
Right. So when you talk about repeal by implication, and again, just going back, that of course the statute doesn't say that. It never says anything about repeal by implication or repeal by practical effect or anything like that. I think that even if you use those cases, and there's another one I would suggest you consult that's more recent called, or not after 1945, I should say, called Keener versus Carnahan. Keener had to do with whether constitutional provisions repeal each other by implication. And I mentioned that one because I'm sure the court is thinking, repeal one constitutional provision by implication of another? That's almost never going to happen, right? So the Keener case goes through what repeal by implication really means as well in a context that I think makes a lot of sense. You have to have what, I don't know if it's in the opinion, but at least at oral argument, what one judge of the Court of Appeals referred to as root and branch conflicts, right? The complete and total repugnancy that allows nothing else to stand out of the Constitution or out of the statute that is in question. So this statute, and again, we're talking about statute 116.050 says repeal. Which ones does it repeal? And it says which section does it repeal, not which parts of the statute or which effects it would repeal. So if you're going to read it literally and then add in the word by implication, it would say which sections does the initiative repeal by implication? And so you would have to say that the entire section is gone, Judge.
Thank you, counsel. You're out of time.
Oh, I'm sorry. Thank you.
Thank you, Your Honor, and may it please the court.
You may proceed.
I'm Mary Catherine Martin on behalf of respondents in this case. My clients are here because Amendment 3 does not meet the constitutional and statutory requirements for an initiative petition to be on the ballot. These requirements protect voters. They do not undermine the initiative petition process. They are set forth in the Constitution and the implementing statutes in order to protect all Missouri voters. They do not burden the state of Missouri's voters. They require them to be fully informed in order to properly exercise their rights within the initiative petition process. Our suit is timely, and this court actually favors pre-election review of whether initiative petitions are legally sufficient. In the circuit court, we raised 2 constitutional violations under Article 3, Section 50, and 1 statutory violation under Section 116.050, although with many manifestations, not all of which this court needs to reach. We ask this court to consider all 3 of these claims as the law allows. Namely, in addition to failing to disclose its major effects to Missouri voters, which violates both the Constitution and Section 116.050, Amendment 3 also violated the constitutional single subject rule. Since appellants have asked you to reverse the holding of the circuit court, however, and because you need not, like the circuit court, you need not reach Amendment 3's constitutional infirmities if you affirm the circuit court's conclusion under Section 116.050(2)(2), I'd like to focus on 2 major questions this court must decide in order to affirm the circuit court. The first has already been raised. What is a repeal, and are there some here? The good news is the cases and the parties agree that the definition of repeal comes from the cases that cite Black's Law Dictionary, for an implied repeal is the abrogation or annulling of a previously existing law by the enactment of a subsequent statute which contains provisions so contrary to or irreconcilable with those of the earlier law that only one of the 2 statutes can stand in force. Elsewhere, this court has held that the necessary conflict between 2 provisions would be a direct conflict or an irreconcilable repugnance.
In those cases, though, counsel, the analysis in all those cases deal with whether or not there was direct conflict with 2 constitutional provisions, one a proposed constitutional provision and one existing, and or if it's a statutory initiative, it's a conflict between a proposed statute and an existing statute. I've not found any cases that have analyzed whether and when there was a constitutional provision that may conflict with the statute. Do you have an answer to that?
Just the fact that it has not been raised does not mean that that's not the plain and unambiguous meaning of the statute. And that
It could have been, would you agree, it could have been raised in some of those other cases and it was not? Those
I confess I'm not
allegations.
sufficiently familiar with the ballot measures suggested in those cases to consider whether they had relevant violations of the disclosure statutes or relevant repeals to disclose. This is a statute that is only invoked depending on the scope of the measure proposed. So it does not surprise me that this very novel amendment raises legal questions or asks this court to apply differently, or rather anew, a statute that other people have not necessarily violated. I would also point the court, I would also make the point that the definition of direct conflict and irreconcilable repugnance, it doesn't depend on whether it's going statute to statute or constitutional provision to constitutional provision. All the cases apply that standard, which was articulated in Moore versus Brown. And Moore versus Brown did in fact find 3 irreconcilable repugnances and direct conflicts, and none of them was an entire deletion of the earlier provision. All 3 of them involved a direct hit on only part of the earlier provision. Specifically, Moore versus Brown considered a direct allocation of $29 million to benefit from a general fund to benefit particular beneficiaries. And there were 3 other provisions that constitutional provisions that governed how the general fund would be allocated, and Moore imposed its priority, or rather the new provision in Moore imposed its priority over those other 3 provisions in a partial way, and Moore held that the constitutional provision could not be considered by initiative petition unless it disclosed to voters that it was going to do those 3 partial deletions of earlier provisions. Now, another answer to your Honor's question is simply that we have also argued that they have failed to disclose constitutional provisions. That's constitutional to constitutional, Your Honor. So if you would like to hold that, as we have argued, that the scope of Amendment 3 just as squarely as it hits abortion also hits cloning and IVF, which are in Article 3, Section 38D of our Constitution.
Circuit Court didn't hold that, though.
The Circuit Court did not hold it, but it didn't reach it. In the appellant's brief, they suggest that it did not accept our argument. It did not consider it at all because it found, quite rightly, that there were sufficient statutory violations to avoid a constitutional issue. And the Circuit Court was operating on the same schedule that you find yourselves in. So not only is there a constitutional avoidance principle at play there, but also an efficiency principle, because the violations that the Circuit Court found are evident in the words of the statute, or of the Amendment 3, in a way that, because they used including but not limited to, they avoided mentioning cloning, and they avoided mentioning in vitro fertilization, though they are, we believe, quite clearly just as much all matters relating to reproductive health care as abortion and the other named subjects. So we invite you to hold on constitutional grounds that they violated Article 3, Section 50 and Section 116.05022 by failing to disclose those hits on the Constitution. But we believe, as the Circuit Court did, it would be sufficient to simply consider whether there are some repeals here, direct conflicts with Missouri's dozens and dozens of laws regulating abortion. Let's just begin with what the Circuit Court held. Well, actually, before I get there, let me just point out that the Circuit Court held that the 2 provisions it identified directly conflict with earlier provisions in abortion. But there are actually 2 explicit new laws made in this amendment that, if we want to look for, as the appellant suggests, complete replacements of entire earlier provisions you could look no further than Section 30 of Chapter 188, which defines fetal viability, rather, Section 1512 of Section 188, where fetal viability is defined differently than Amendment 3 defines it, and then Section 30 of Section 188, where the process for discerning fetal viability is restricted to not one but two physicians, which is completely altered in Amendment 3, completely replaced by the requirement that fetal viability can be determined. Fetal viability has a more mature definition and can be determined by any treating healthcare professional. So there we have two complete hits. I would also argue that without using the words, the parental notification and waiting period statutes are gone. Those are both impediments to the exercise of reproductive freedom, and they will not survive Amendment 3. That is four separate provisions that are completely replaced by Amendment 3. Now we can go to what the district court said. The district court said, in Section 188, Section 17.2, any person who knowingly performs or induces an abortion of an unborn child in violation of this subsection shall be guilty of a Class B felony, as well as subject to suspension or revocation of his or her professional license by his or her professional licensing board. Amendment 3 states, nor shall any person assisting a person in exercising their right to reproductive freedom with that person's consent be penalized, prosecuted, or otherwise subjected to adverse action for doing so. So, on the day before Amendment 3 went into effect, it is a felony and subject to losing your license if you perform an abortion in Missouri. The day after Amendment 3 goes into effect, you're completely immune from suit. These two provisions cannot coexist. One completely repeals the other.
Are you immune from suit? Or could you be charged and you'd have to raise a constitutional claim that the charge and/or the suit violates the Constitution? Wouldn't there have to be a finding from the court first to determine that there would?
Well, the first person would have to raise it as a defense. But that kind of conflict is evidence enough for the court to find that it is direct. It is not one of the unnamed subjects. We're not asking for interpretation. And in fact, the statute doesn't require this court, and this case does not require this court, to determine the outer limits of everything, or the drafters, to the outer limits of everything that could eventually happen with the adoption of Amendment 3. It requires only substantial compliance with the disclosure requirements on the statutory level. Let me be clear, it is a strict violation of the Constitution to not reveal that it will repeal the ban on cloning, because that is constitutional. However, under the statute, substantial compliance is all that is required. And so the measure of whether something should be repealed is what this court has required when applying other matters as to form, which are not technical requirements. They are not merely technical that can be waived. The court requires substantial compliance with them by requiring that any failure to meet them must not mislead the voters. So if you find that that one of the repeals here was sufficiently direct that it should have been disclosed, then all you need to find, you can follow up to find that it's squarely within the statute, is that leaving out the information that, for instance, Amendment 3 would repeal our ban on abortion, or repeal Section 17, or 27, or 28, or 30, or 15, that leaving that out would have been misleading to the voters. Another way of saying that is, would a voter's mind have been changed? Would their position on this have been different if they had known that that was the effect of the statute? Now, if you want to look at the text with me, we can see whether an ordinary voter might know otherwise what was happening to abortion just by reading what's in the text. as appellants have repeatedly stated, all this text does is add. It just adds to the Constitution. It adds a new right that we should be very excited about. And then down in section 4, it doesn't say we're going to limit abortion, we're going to prohibit abortion. In section 4, it allows the General Assembly to regulate abortion. The average voter reading this would have no way of knowing that it has a limiting effect unless they were a lawyer and in section 4 they thought to themselves, why do I need the General Assembly to have the right to limit abortion after viability? Did something in sections 2 and 3 take that right away? This is a provision that does not reveal on its face what it's doing. Therefore, keeping from voters the fact that it makes such substantial repeals absolutely misled the voters. And in fact, we had a submission from an amicus in an amicus brief with one such voter. And I'll yield the rest of my time to the Secretary of State. Thank you.
Thank you.
Wow. I feel like she kind of blew up her own argument.
Madam Chief Justice, and may it please the court.
You may proceed.
Very quickly, a couple points about timeliness, mootness, and if I get to it, constitutionality. On timeliness, the intervener's argument is neither preserved nor does it have any merit. It's not preserved because the part of their answer that they cite for preservation expressly advances the exact opposite argument to what they are contending here. Their answer says the correct window to bring a suit over this is sometime between August 13th and the 23rd. And they just think it's closer to the beginning of that window than toward the end. Now they say the exact opposite. They say that 10-day window is the only time where you can't sue over this. So that's not preserved. It also makes no sense. They say, well, maybe they can sue at phase 1 when the secretary makes a decision about legal content and form. But there's no cause of action there. That's why Fitzjames last year had to bring a writ of mandamus. And then they say, well, maybe Coleman should have brought this along with her challenge last year to the ballot title. But under 116.190, you can only challenge the ballot title in the fiscal summary at that time. You can't do anything else. So then they say, well, maybe this is like the Lucas case or the Buchanan case where you should sue after the election. Of course, that's disfavored. And there's also no cause of action here. So what we have is a strange argument from the interveners that the only time you can't sue over this is during this 10-day window, even though that 10-day window is the only time where there's an actual statutory cause of action. But more fundamentally, this court should simply dismiss this appeal because the appeal has now become moot. The secretary yesterday decertified the ballot amendment. And I want to be clear that the secretary's decision yesterday is not before this court because the interveners have not amended their pleadings or done anything like that to challenge the secretary's actions. Now, of course, this court did enter a stay of the trial court's injunction. But of course, a stay is very different from an injunction. A stay does not operate in personam. It operates on the judicial proceeding itself. And so the secretary was never under any injunction prohibiting him from decertifying this ballot measure. It's no different than if the secretary—
What's the statutory authority to decertify? Is that the statute doesn't refer to any authority to decertify, just to certify.
So the secretary is relying here on the Sweeney case. And initially when he made this decision, he was relying on the Fitzjames against Bailey case, thought that certifying this was basically an automatic thing that he had to do. And then this lawsuit is brought and both sides cite the Sweeney case, the plaintiffs and the interveners cite the Sweeney case. And so the secretary reassessed, took a look at the Sweeney decision and determined that the Sweeney decision authorizes him to do this as long as he makes a certification or decertification decision anytime before, at least 8 weeks before the election. So that's what he did. If they want to challenge that, they're free to go ahead and do that. They haven't challenged that as of this morning. So this is no different than if the secretary had issued a decertification decision last Thursday, for example, having looked at the pretrial briefs, having determined that in fact he was wrong when he initially certified it. It's no different from that circumstance, and that's there. Very quickly, on the constitutional issue, my friend on the other side, the interveners, their argument runs into squarely binding precedents. The Buchanan against Kirkpatrick case, for example, from 1981, took a look at this exact requirement and says that this requirement succeeds in substantially bringing out the effect of the proposed amendment without placing an excessive burden. My friend, to succeed, he has to convince this court to overturn a variety of different precedents from this court. So we would ask that the appeal be dismissed.
Thank you, counsel.
Counselor, is your research consistent with Judge Powell's that it is an open question or an issue of first impression as to whether or not constitutional provisions have to disclose statutory repeals and vice versa?
It is.
Yeah, so it's purely an issue of first impression that's not been decided by any of our prior cases.
I believe that's correct. So Keener goes constitution to constitution, and the other cases we've been talking about go statute to statute. And the Ritter Buchanan, I mean, I want to be clear. I think Ritter Buchanan, you ought to overrule them. You ought to correct. Those are Court of Appeals cases, not your cases. I think at least Ritter and Knight are. I think you ought to overrule them. I think you ought to clarify the law that should be applied go forward, and it's not to do this repeal by implication analysis, which is a judicial function. It's a function of the judiciary to make a decision on whether something's repealed by implication. I do want to talk about what the Secretary of State just told you, which was not in the brief. They didn't say, hey, it's moved. They didn't even give you the letter that they sent to my client decertifying when they dropped a footnote and said, oh, by the way, we decertified this morning. We had to provide that letter. I'm now told that the Secretary has removed the measure from its website. So the public now thinks that this matter is not certified anymore. And I want to make sure we understand the context of what has happened. There was a decision on Friday night. There was an appeal filed on Saturday morning. Western District transferred the matter here on Saturday morning. On Sunday, we filed an application for stay, and we said the Secretary of State is going to be up to shenanigans, and we need a stay from you. To be clear, read the stay order, which we served on them, and said we don't want them doing anything on Tuesday that is going to be in violation of the stay and is going to cause a crisis in the system. And they went and they did exactly what we told you they were going to do. It's a violation of your stay in the context.
Well, just to be precise, and I think you and I agree on this, the order from this court was that the circuit court's stay would remain in place until further order of this court.
Right.
So the issue of contempt or whether anybody's in violation of the stay, it would be an analysis of the circuit court's stay. Which we extended
yes,
until order of our court.
Yes, sir. Let me talk about the second reason that we decided to file a motion of contempt. It's highly unusual, and I understand the predicament it puts you in to have the Secretary of State do this and then us say that's contempt. This court has authority over this process right now. The public has been told, as they should have been, that you're going to decide whether this measure is on the ballot or not. And that's true. You're going to decide that. The Secretary of State went and told them, no, you don't have any authority to decide whether it's on the ballot. He just decertified it. It's open contempt for your authority. It's open contempt for the rule of law. It's open contempt for the proper administration of justice to tell the public that he's going to take it off the ballot, even though we're here this morning having this discussion. And that's why we filed the motion we did. His actions are governed by statute. He had till August the 22nd, whatever day it was, to certify the ballot, and he did it. He's actually done it twice, and he told the circuit court below that his decision was right. It's over and done with. And as we said, I believe in the motion for contempt, it is functus officio. It is not a decision that he can go back and redo now. And to tell you, oh, sorry, Judge.
Counsel, you're out of time.
Not doing a very good job of monitoring.
Thank you.
We believe the court should reverse.
Thank you. The matter will be taken as submitted.
It's over, man. Yeah, so yeah, that was the arguments, which were really interesting. I think so. The main arguments that the the respondent is arguing. And so the respondent is basically, and let me know if you need any clarification, because this does get a little bit confusing. So there is Mary Ann Coleman filed a petition in Cole County, basically stating that this Amendment 3, the abortion question, should be removed from the ballot because it violates the constitutional provisions of the ballot initiative, or that mandate the ballot initiative, because it doesn't disclose all of the provisions that this Amendment 3 would be repealing or making invalid if the voters, vote to pass this ballot initiative. And so she basically states that because there wasn't that proper disclosure, the ballot, or the Amendment 3 on face, is unconstitutional. When that was filed, Rush Limbaugh's cousin was the circuit court judge that heard this case in Cole County. And he basically agreed with their argument, but gave the other side an opportunity to appeal to the Supreme Court before the deadline to decide whether or not this should be on November's ballot, which is today. So they gave the side that wants the abortion question on the November ballot literally only 4 days to prepare this entire argument, which I really want to stress that, because that's hardly any time at all. And the fact that the Supreme Court literally only had 5 days to do the research and to understand the very technical issues of this case is low-key ridiculous. I believe that Coleman, if they had any issues with this initiative petition, they should have brought up these arguments way beforehand. Like, for instance, when the initiative petition was finally printed in February, they had all that time to bring up this argument to the Supreme Court or to Cole County, saying, hey, this ballot initiative is invalid because it does not substantially comply with the disclosure rules, which states what this ballot measure will do. But they literally waited until the last minute, and this is all strategy by the people who do not want this question on the ballot. This is all by design, in order to rush the entire process. And so based on that, it is shameful what they're doing. They're not giving the court enough time to really consider all of the legal issues, and to essentially, they're essentially going to make a rush judgment, because like I said, the Supreme Court only had 5 days to consider this argument, which, if you look at the filings on this case, there's hundreds of pages of arguments, right, that have citations to probably over 25 statutes, constitutional provisions, and cases. In each of those cases, like for instance, the Moore versus Brown case is over, is like 32 pages long. So you can only imagine the Herculean effort that the Missouri Supreme Court right now has to go through in order to issue their decision today. Okay, they're going to issue their decision today as to whether or not the abortion question should be on the ballot. And for that reason, I think this whole matter is completely ridiculous. With that said, I don't know how the Missouri Supreme Court is going to go. Usually during these oral arguments, you kind of get an indication as to where the Supreme Court is heading. when it comes to the questions that they're asking to the person who's presenting the oral argument, but they were applying pressure to both sides. But these are the ones that I wrote down, the main arguments that the Supreme Court seemed to really pay attention to. The first one is they're probably going to answer the question as to whether or not this ballot initiative does a repeal by implication. And if it does, then whether or not that has to be disclosed in the ballot initiative process. As they were arguing under the constitutional rules for ballot initiative. I don't know if it's a constitutional rule or if it's a statute rule, but the rules that the ballot initiative petition has to follow, they have to substantially their ballot language has to have substantial compliance. That means that they don't have to disclose every single law, ordinance, code that this ballot initiative would affect, but they have to their petition has to just disclose essentially the nature of what this question or what this initiative would do if the voters approve it, which in layman terms, I believe that the ballot amendment 3 or the abortion question did disclose that. Everyone knew that this was going to be a ballot measure in order to remove the ban on abortion. If you go out and ask a layperson in the streets what Amendment 3 or the abortion question is about, they will say, well, it's a question as to whether or not to allow abortion in the state of Missouri, which essentially is what what people the voters know what they're voting about. That's what I'm saying. And one thing I want to bring up too is this also shows that the respondents, who are the people that filed the petition in order to remove the abortion question from the ballot, they really don't believe in the will of the voters. They don't believe that the voters are smart enough to understand what they're voting for. They believe that the initiative petition was misled voters, which as a person who collected over 200 signatures, I'll tell you that the average person that came up to me to talk about signing or refusing to sign this petition, they knew exactly what the purpose of this ballot initiative or this ballot measure was going to do, which is to ensure reproductive freedom rights in Missouri, or to allow abortion. Especially the people that were against this, they made it very clear that that they were not going to sign this ballot initiative because of what would happen if the voters approve this bill. Another argument that the Supreme Court brought up that I thought was important was they basically stated that the statute. So John Ashcroft yesterday decertified Amendment 3 from the November ballot on his own before this ruling even happened. And the Supreme Court basically states that the statute specifically states the Secretary of State does not have the authority to decertify ballot initiatives, which I thought was really interesting. And so that gives me the indication that right now, when it comes to the Supreme Court's analysis, as far as John Ashcroft's actions that he took yesterday to decertify, I believe on that point, they're going to overrule that decertification, okay? Because they already basically says that the Secretary of State only has the power to certify and decertify, and the Secretary of State can't certify an action and then retroactively go back and decertify that action. As I stated earlier, the Secretary of State could have brought up these arguments before he certified the question for the November ballot. Another argument that was brought up by a Supreme Court judge was that, and this was on the respondent side, the Supreme Court judge basically says that he basically alluded that in his belief, there needs to be disclosure of direct conflict with the statute. And in the respondent's petition that they filed in Cole County in order to remove the abortion question, they did not cite to any statute that shows this direct conflict that was not disclosed in the initiative petition. The respondent basically responds to that argument saying that they, that they didn't have time. They're basically saying excuses as to why they didn't show that that the initiative petition did not disclose a statute that allowing access to abortions in Missouri would have a direct conflict with. But that also shows that I think with that judge, he's. I don't want to assume anything, but in my opinion, I think the Supreme Court of Missouri is going to rule that the abortion question should be put on the ballot. I think that the respondent's argument that the initiative petition did not substantially comply or did not have substantial compliance, did not substantially disclose what this petition or what the ballot initiative would do if passed is very weak. And because I think that the average person understands exactly what will happen to our laws regarding to abortion if this initiative petition is passed. And I also say that too because there was a rigorous fight between the people who wanted the abortion question on the ballot 5 years ago versus the people who have been fighting to not allow the voters to vote specifically on this abortion question for years. And it took them all these years to finally get the Secretary of State to agree to the ballot language of the initiative petition that they started collecting signatures on in February. And so to say that the initiative petition that we collected over 380,000 signatures on does not substantially disclose to the voters of Missouri the nature of what this measure will do if passed is ridiculous, because this initiative petition has gone under extreme scrutiny. And therefore, I think, in my opinion, I hope the Supreme Court reverses the Cole County Circuit Court judge's order in order to have this question, or allow the voters to be able to vote on this question in November. I also feel that if the Supreme Court rules that that Amendment 3, the abortion questions ballot language, did not substantially disclose everything that it would affect if the voters voted to enact this procedure and removes it from the ballot, I think that's going to have enormous implications with the voters of Missouri, both people who support the ballot initiative and people who do not support the ballot initiative. Because in this whole show that the respondent, the petitioners, the people who are trying to get this removed from the ballot, they're basically telling the voters that that they don't care to hear the voters' vote or voters' voice on these issues unless these are issues that they agree with. And that is completely wrong. And and utterly disgusting. They are trying to strip away our rights in order to have a say as to whether or not to allow abortion in Missouri. But this isn't just about abortion. This is about initiative petitions in general. And historically, initiative petitions are, in my opinion, by far the most democratic process that the United States government has, because this is basically the people gathering signatures from their from their own residents, stating that, hey, we want this, and then bringing it to the people to decide whether or not to allow this in their area. And they're trying to strip away our ability to do it just because they don't one, agree with the ballot initiative petition, but two, they are in fear that the ballot initiative is going to pass. And so this is another way that they're trying to ensure that we keep this ban on abortion in Missouri. And I think that that's completely wrong. But anyways, that's my opinions on this. We'll see. The Supreme Court of Missouri is going to issue their opinion today. I have friends that are law clerks, not in the Supreme Court of Missouri. Okay. So I do not have any insider information about what's going on in the Supreme Court of Missouri, but I do in general have friends that are law clerks, and usually before the oral argument, most of the time, and I shouldn't say most of the time, but there's usually the opinion is written before the oral arguments take place. And unless something substantial happens, like during the oral arguments, one of the parties makes this brilliant point that completely changes the Supreme Court's mind and interpretation as to what their opinions were. That opinion that is usually pre-written before the oral arguments take place is probably going to be submitted today. But I don't know if that is so in this case. But in general, the opinions are written before the oral arguments take place. That's just some insider knowledge for you guys. But anyways, if you guys have any questions for me, please leave it in the chat. Or otherwise, I am going to continue with my day. And so if I don't get any questions in 5 minutes, I'm going to log out. But just to let you know, this day has been extremely hectic for me because yesterday I had a deadline. I had a legal deadline to fulfill, which I did, but I was working, and I know I had a live on Sunday, but I was working Friday to Monday, just every single hour, just typing. I submitted it in last night. And so then I think it was like, it was very late. It was like around 11 o'clock. I look at the news, which is like the first time I saw the news yesterday, and I saw the whole John Ashcroft fiasco. And I just, in my gut, it didn't sit right with me. And like at 7 o'clock, I basically turned to my husband and I said, I really want to go live, but I don't know if I should. And my husband's like, you need to go live. And so I'm glad that I made the choice to go live today, because this issue is extremely important, because it will change not only the way that the Missouri government's going to handle ballot initiative petitions in the future, but it's going to change the course of this election, because I believe if the abortion question is on the ballot, it's going to bring a lot more voters to the polls than if it wasn't on the ballot. And that's what the people who are trying to remove this from the ballot, I believe, fear, and they're trying to prevent, which it doesn't get any more undemocratic than that. But anyways, I see that there's no questions. So I'm just going to end this live so I can continue on with my day. I hope you guys had a fun time listening to the oral arguments of the Missouri Supreme Court. I will update my social media as soon as the Missouri Supreme Court issues their ruling, which should happen later on today. And I hope everybody's in general is having a great Tuesday morning and will continue to have a great day. Anyways, until next time, you guys, see you.